Hi everybody, Scott Nell here with the Scott Nell team. I'm here with Armine Bazikyan with the Bazikyan Law Group. Armine is a phenomenal estate planning attorney. And our topic of today is what are the pros and cons of taking title to a property as community property. So tell us what we need to know. What are the advantages of it, and what are the things we really need to watch out for?
So community property is a form of property ownership. It's a way of taking title to real property. And it can be done between spouses only. The key to community property ownership is that it has to be between spouses. So you and I cannot go out and buy real estate and take title as community property. That would not work. Whereas my husband and I, when we buy property, we can choose community property during the escrow process as the method by which we're actually taking.
Why are you saying that though? So it's just husband and wife? It couldn't be like a brother and a sister or any other family?
Nope.
It's just husband and wife, period.
Husband and wife.
Perfect.
We live in a community property state.
Absolutely.
Right? So it's spouses. So let's back up. It could be husband and wife and wife.
You see?
So by saying husband and wife, we don't necessarily mean husband and it has to be of the opposite sex. So it's basically spouses taking title to a real piece of property, to real estate together.
Okay.
And it's great. It's a great form of taking property ownership because of all the tax advantages that come with it. And by tax advantages, we're talking about one specific advantage when it comes to capital gains tax. We're talking about step-up in basis. So
before you go into that, because a lot of people that get confused on that. So what are capital gains, and what is a step-up in basis?
So these are two complex topics. I'm going to try to do it in like 3 sentences or less.
Okay.
So capital gains taxes are assessed when you have a property and then years down the line you go and you sell it. The government wants to make sure that that profit that you make on that property, some of that goes to them.
Right.
Okay? They don't want you to keep that cushion of profit that you made. So that's capital gains tax.
Perfect.
Okay? Step up in basis, the government says, yes, we're going to tax you on the gain on those assets that you've sold. And if you acquired it in a certain way, will allow you to actually get what's called a step up or step down. So for example, if I inherit my mom and dad's house, when it gets transferred over into my name and I turn around and I sell it, I'm not going to get taxed on my sales price minus what my parents bought it for back in like the 90s. I'm going to get taxed on the sales price minus their date of death. So my capital gains is going to be very, very little, hopefully, because I've stepped up to their date of death value.
Right.
Okay? It's a huge tax benefit that the IRS allows. And the good thing about community property is that when spouses take it as community property, when one spouse dies, which is usually the event that sparks the other spouse to rethink where they want to live, and that's usually when they do a lot of changes in their life. They don't have to be bound by capital gains. They don't have to fear that they're going to pay a tremendous amount in capital gains because they bought this house back in like the 70s. They can freely think about the possibility of selling the home, and they can get what's called a step up. They can step up the value of the property to the date of death of their spouse, and not incur, or maybe incur capital gains, but very little. So that's the pure advantage of capital gain, of community property that we like to see and to use. So a lot of times with spouses, we encourage them to take property as community property because of that advantage.
Right. Excellent. Okay, so tell us some of the downsides of community property.
Okay, so the downside is that your property that you own as community property with your spouse, it's 50% yours and it's 50% your spouse's, which means that your spouse can do whatever he or she wants with his 50% share, right? And I say that within certain limitations. So there is no presumption of survivor here. So if one spouse dies, it doesn't just automatically go to the survivor. It actually goes to whoever that spouse delineated. So most of the time, so it gets a little bit complex. So normally, if you have, Sam and Sally owning property as community property, if Sam passes away, we can't just transfer the rest of the property to Sally. We actually have to go to court and do a spousal property petition. And that's how we're going to get the property over into Sally's name. So she will end up with the entire property at some point, but it's going to be this like costly court process that she has to go through.
Right.
Whereas in joint tenancy, another way of taking property ownership, it would just automatically pass to her by operation of law. It would be a very simple process. So a lot of times couples don't take title to their property using community property because they're afraid that if something happens, I have to go to court.
Right.
So they'll avoid it, not knowing about all the great tax advantages to it.
So how does having the property in some type of an entity affect this?
You mean like an LLC?
Yep.
Normally spouses don't buy their home in an entity, they buy it in their names individually, but if they had like an investment property, for example, it would be the same advantage. As long as they own or they maintain that property as community property, they can get that step up in basis for capital gains purposes.
Okay, excellent. So one more question for you. Someone comes in and they're thinking of buying a property. What do you talk them through? Do you have steps that you talk them through in order to figure out exactly what would be the best way to invest?
So it would depend on their goals, right? So if it's a couple, then we're going to want them to take it in community property because we want those tax advantages if something happens to one of them. But then the question is, are they going to do a trust right away? If they're not going to create a trust right away, then we might take title as community property with right of survivorship, which is basically like the holy grail of taking title to property for spouses, because you get to have the tax advantages of community property and you get to have the survival advantages of joint tenancy. So you have your cake and you eat it too, right?
Nice. Okay.
So you can take title with community property with right of survivorship until you figure out your estate plan and all that. And in the meantime, you'll be protected because you'll get the tax advantage, and if something happens, you don't have to go to court. You could do an affidavit procedure with the county and give them a death certificate and transfer it over to the other spouse.
Nice. So if you've learned anything today, it's you need a great estate planning attorney because this stuff gets so darn confusing. Thank you very much.
You're welcome.
Hey everyone, if you'd like more information about myself or my amazing team, check out scottnellteam.com or subscribe to our YouTube channel. Thanks for watching.